Alex here with part 225 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my external rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the last two videos of this particular series and their cleanup. I'm just cleaning up the docket a little bit with this video, and then in the next video I am ordering the videos for the adoption, which you guys ended up watching. So I'm going to wrap up the My Docket series in two videos, and I will definitely continue to do this series. And what I'll do is go through some of the other cases that I have filed, and once I'm done with all my cases, then maybe I'll take a look at other people's cases, especially once the website starts taking actual input from viewers, which is not quite ready yet, but very close. In fact, the other website is partially completed, and maybe I'll mention that in the next video. Maybe I'll go through like a screen share of it on its own dedicated video. We'll decide. But anyway, there's some new stuff coming up. This specific video will involve two motions that I filed to remove things from the docket that shouldn't have been there. They're mistakes, documents that were filed by, I believe, one of my attorneys from way back that were documents from some other individual. Most likely she just included the wrong documents and submitted them, and they just ended up in the docket. And so because this case is going to involve people doing public records requests, which has actually already occurred, I figured for the sake of the privacy of these other individuals who I don't even know who they are, and their banking information and stuff like that was in the docket, and it shouldn't have been there because it's not their case. It was probably just supposed to go under a different case number, and for whatever reason it was put under mine. So that's what's going on with this video. No mindset really. The judge granted both the orders, so I was like, okay, that's great. And that's really all I have to say about it for the beginning portion. Let's go ahead at this point and take a look at what I have filed. Here we have my motion to strike, or in the alternative, to direct the clerk of the court to deem a filing in error. Standard introductory paragraph. I'm introducing myself to the court, filing an ex parte motion to strike. Please take a look at my video on the topic ex parte perils. Typically, this is not the appropriate way to communicate with a court, but in this situation, this is something that doesn't affect me or my ex. I'm just asking the court to remove a filing from some stranger that nobody knows that has, banking information from this particular person there. And so my thought was, why should my ex have notice of this? It's not going to affect anybody's rights, and it could actually cause harm to the individual if she, for some reason, disseminated the information. Not that I think she would have, but I figured may as well just do it ex parte because this has nothing to do with anybody. On July 6, 2018, a motion for Rule 60 relief from order for change of venue and for dismissal with prejudice was filed. The pleading should have been filed in a different case, so I actually have the case number on there. I have contacted the clerk of the court and requested it deemed filed in error. The clerk refused and instructed me to obtain a court order. It has no relevance to this case, and pleadings filed in guardianship cases are generally confidential. Furthermore, it mentions nothing of respondent and would not prejudice respondent to strike it. It just is not supposed to be in this case. I state that I have read this motion, that the contents are true and correct. And so that takes care of that first document. Here's my request for submission on the ex parte motion. If you want to learn more about a request for submission, please watch my video on the topic, request for submission. Next, we have an order regarding motion to strike. The court has reviewed my motion to strike, or in the alternative, to direct the clerk to deem a filing an error. The court notes that the motion was incorrectly filed in this case. The court is directing staff to remove it from this case. The court further notes that I have already filed the document in the correct case, and therefore no further action is necessary. Certificate of service under Rule 5, indicating that this document was, addressed to mailed to my ex. We have the satisfaction of judgment. If you want to learn more about the satisfaction of judgment, I have a video dedicated to the topic, and it's titled Satisfaction of Judgment. It's actually in the legal nuts and bolts category. This basically lets the clerk know that the entire judgment has been satisfied, and the collection agencies will typically, I don't know how they do it, but they check court dockets. I don't know if it's automated or what. And if a collection agency sees a satisfaction of judgment, they will note it in their records. So it does benefit my ex for me to file this. Next, we have another request for submission. What is this? Okay, so this is another filing. This is for another ex parte motion. It looks like I got it out of order, but that's okay. You guys get the idea. Here is what I was talking about in that request for submission. This is an ex parte motion to direct the clerk to, again, remove a filing. Standard introductory paragraph again. The same memorandum of points and authorities. This case is closed, and all child custody issues are irrevocably resolved. On November 10th, looks like a notice of entry of order and continuation was filed in error by my attorney of record at the time. The contents of the filing are not as claimed by the docket, but rather that of an individual unknown to petitioner, and containing substantial and private banking information. As stated in the ex parte motion filed January 9th, 2020, the clerk will not remove documents unless directed to do so. Removing this filing ex parte would not prejudice my ex and would protect the individual's privacy from members of the public making case inquiries on the docket. And you can see here in a footnote that it's been brought to my attention that viewers from these two channels that I have been conducting research on this and all associated dockets. And so what I'm trying to do is protect the privacy of this individual, because his banking information shouldn't have been in the docket. I don't know who this person is or why that happened, except that I can speculate that it was an accident. Next, we have an order granting ex parte motion and directing the clerk to remove a filing. The court has reviewed my ex parte motion, and I am requesting the court direct the clerk to remove a document filed by my attorney on November 10th. I'm claiming the document relates to an unknown individual and contains substantial and private banking information. Upon review, the court finds that the reference document was incorrectly filed and does not relate to any order in this case. The court is directing staff to remove the filing from this case. Next, we have a notice of writ of mandamus. This is just an extraneous filing. Looks like, who filed this? It looks like it was filed by the clerk. Okay, so the clerk of the court filed this notice of writ of mandamus to let this judge know that I had filed a petition for writ of mandamus in the Supreme Court. The clerk was doing what she was required to do under the rules of appellate procedure. I have seen that rule. And so this clerk was just complying with the rules of appellate procedure and letting this judge know, hey, Alex filed a petition for writ of mandamus in the Supreme Court. That's it. Nothing else to it. If you want to learn more about how rules control cases, you can watch my video on the topic, statutes, rules, and case law. Going into the aftermath, I have filed, it looks like 1, 2, 3, 4, 5 documents. Those are all free filings, so I have incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.